Judgment in the appeal of the Catholic Child Welfare Society and others against various claimants and the Institute of Brothers of the Christian School.
Lady Hale will give the judgment.
The issue in this appeal is whether the Institute of the Brothers of the Christian Schools is vicariously liable for acts of sexual and physical abuse allegedly committed by its members at St William's School in Market Wheaton in Yorkshire. The school was closed in 1994 following the conviction of its headmaster, Brother James, of serious sexual offences against boys in the school. St William's was what used to be known as an approved school and later became a community home with education on the premises. The boys living there were particularly vulnerable because they were virtually prisoners and because their personal histories made it less likely that their complaints would be believed. 170 of them have brought claims in respect of alleged abuse by Brother James and other brothers at the school. The Christian Brothers did not own the school. The statutory managers are now represented by the Catholic Child Welfare Society of the Diocese of Middlesbrough. They employed the brothers who taught at the school. They accept that they are vicariously liable for the alleged abuse, but they argue that the Institute shares that liability with them. The High Court and the Court of Appeal both held that the Institute was not vicariously liable. The Supreme Court holds that it is. The judgment is given by our former President, Lord Phillips, with whom all the other members of the Court agree. It is now established that an unincorporated association, such as the Institute, may be vicariously liable for the wrongful acts of its members. It is also established that there may be vicarious liability for acts of physical and sexual abuse, even though such acts are emphatically not what the abusers were called upon to do. And it is now established that it is possible for two or more defendants to share vicarious liability for a single wrongful act. The question, therefore, is first whether the relationship between the brothers and the Institute, though not the paradigm case of employer and employee, was one which was capable of giving rise to vicarious liability. And second, whether the connection between that relationship and the alleged abuse was such as to render the Institute liable. The Court answers both of those questions in the affirmative. The relationship between the brothers and the Institute had all the essential elements of that between employer and employee. The mission of the Institute was to teach. That was also the mission and apostolate of the brothers. The Institute controlled every aspect of their lives, including where they were sent to teach. The brothers transferred their earnings to the Institute, which provided for their needs. The necessary close connection between that relationship and the acts of abuse was supplied because the Institute had required the brothers to carry out its mission or business of teaching, and had done so in a way which created or significantly enhanced the risk of abuse should a brother have such a propensity. The boys were vulnerable, and the brothers were not only in close proximity to them, but had been placed in a position of particular authority over them, both as teachers and as men of God. This was not, therefore, a borderline case, but one in which it was fair, just, and reasonable that the Institute should share vicarious liability for any abuse with the statutory managers of the school.
The Court is now adjourned.